go live now. Read the court cry. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to today's session of the Appeals Court. In this particular case, which is 20P1102, John Doe 6729 versus the Sex Offender Registry Board, we are prepared to proceed via our Zoom format. I'm joined today by Justice Vicki Henry and Justice Catherine Hand. Ms. Green, when you're ready, you may proceed.
Thank you. Good morning. May it please the court. Ashley Green here today representing Doe 6729. As the court is well aware, this is Mr. Doe's appeal of a level 3 classification, deeming him a high-risk offender. There were numerous errors that occurred in the hearing examiner's decision. The culmination of these errors results in the need for a remand of this decision. I would like, if the court doesn't mind, to start with my third argument that was put forth in my brief, that argument having to do with the erroneous application of factor 24, which was the quote-unquote refusal or denial to engage in sex offender treatment. Now, the board's regulation...
Sorry, before you start, could I just interrupt and ask this question? If I read the SORB's brief correctly, SORB is arguing initially that none of these issues was raised below. What's your response to that? Sure.
So the argument regarding factor 24 was raised in the Superior Court by prior counsel, and that issue had to do with the denial of sex offender treatment. That was also discussed during the 30A decision. Arguably, it was decided in error, but it was discussed during the 30A proceedings.
Do you have record sites for that?
Sure. So the issue was raised in volume 4, page 169. The issue was raised regarding denial. The petitioner raised the argument saying that the denial for participation of sex offender treatment does not equal increased risk of reoffense. They also submitted articles to support that position.
I'm sorry, volume 4, 169?
4, page 169, correct. At volume 4, page 182, the SORB responded in opposition to that position, doubling down, saying risk of reoffense and degree of danger are increased by refusal to participate in sex offender treatment. And then at the decision addendum, pages 106 and 107, the Superior Court judge responded in his decision to this argument. So to just go from there, the decision at 30A, the error occurred where that deciding judge did not cite to Doe 23656, which was a 2019 decision. So it was around at the time that the 30A decision was issued. Now, Doe 3656 finds that in SORB proceedings, the refusal to engage in sex offender treatment because a petitioner is not willing to waive confidentiality cannot be held against that petitioner in his classification proceedings to increase his risk of reoffense. That is exactly what happened in this case. My client refused to participate in sex offender treatment. In the record, there is a statement of why he did not participate in sex offender treatment. In his parole records, it says that he refused to participate in sex offender treatment because he was afraid that what was going to be said during treatment would be used against him in other proceedings.
So the board says he said that at some point, but that much earlier he had a different reason that doesn't qualify under the case law. What do you say to that?
The record is clear in that he refused based on confidentiality issues. I submit that the board did not produce the evidence to show that this confidentiality reasoning did not exist. It simply is in the record. It's straightforward. My client made that statement while he was incarcerated. Further, during the hearing evidence, there was evidence submitted that he was willing to participate in treatment once he was released, and the confidentiality issue didn't exist. So the record is very clear here that his refusal was based on his refusal to waive confidentiality. Now, the hearing examiner specifically stated in the decision that his refusal to participate in sex offender treatment increases his risk of reoffense. She acknowledged that it was that he was putting forth a confidentiality reasoning, and still went forward and held that as risk of reoffense. Now that error occurred, and that error was upheld at Superior Court. There was a further error at Superior Court where that decision was issued without any acknowledgement of the court's decision in 23656. The constitutional due process issues that were raised, the liberty and privacy interests that have now been acknowledged in SORB proceedings, cannot be ignored in this case. The Commonwealth v. Hunt decision said that SDP proceedings can, in those cases, if a client refuses sex offender treatment based on confidentiality, that cannot be held against him. Doe 23656 took that decision, brought it over into SORB proceedings, and that is precisely what we're dealing with in this case.
So, counsel, the board says, and they're citing Record Appendix 182, that the plaintiff said for personal reasons he cannot discuss the sex offense. So why is that sufficient to raise the point you're making now?
Because that is not the only place in the record that my client made a statement regarding refusal to engage in sex offender treatment. And arguably personal reasons could be confidentiality reasons, but at the other part of the record at volume 4, page 74, the statement by the parole board is, subject is a sex offender not in treatment. He refuses to discuss the offense as he does not want anything to be used against him at his civil commitment hearing. Does not meet the legal standard. Now, I do not know what does not meet the legal standard means. I don't know what legal standard. I don't know who is making that judgment. It is very obscure, that statement at the end. However, what I do know is that my client told somebody that he is not willing to engage in sex offender treatment because he doesn't want anything used against him at his civil commitment hearing.
So
and
the statement you're quoting is in 2019. The statement they're quoting is in 2017. So let's just assume for a moment that the only statement we had was the 2017 statement. You are contending that, quote, personal reasons should be enough to alert that that he's not wanting to participate because of self-incrimination reasons?
I cannot put myself in the head of my client. However, I will submit that the statement in 2017 does nothing to retract from the position that my client refused treatment based on confidentiality concerns. I don't think that the 2017 statement detracts from it. I don't think it adds to it. I think it is just a statement for personal reasons. He didn't want to engage in treatment. We could read into that, but it would be very speculative to decide what that means.
What I'm trying to get at is, at what point in time do we determine why he didn't participate, and who has the burden of proof on this issue?
Well, the burden is on the board to show that he is a high risk to reoffend. They're using this as evidence that it increases his risk to reoffend, but this fails because the case law is clear and the scientific research is clear that if a person is refusing sex offender treatment because of confidentiality, that cannot be deemed a refusal to participate in treatment, as the scientific research shows. especially in a case where my client said that he's completely willing to engage in treatment once he was released and had therapy or counseling available to him. So they cannot take the position that there is no willingness to engage in treatment when the record is clear. He refused based on confidentiality concerns.
But isn't that for the hearing examiner to make an assessment as far as the credibility of those statements? She is not required to believe your client's representation that he intends to undertake treatment, nor does that speak to whether he has in the past been willing to undertake treatment. And likewise, to Judge Henry's point, couldn't the hearing examiner see as more credible the original reason given for the for your client's non-participation in the treatment?
No, because it was an error of law to ignore statements. I mean, the case law is clear. The hearing examiner didn't say that she didn't believe that he was refusing treatment because of confidentiality issues. She never said that.
And I'm sorry to interrupt you, but looking at this, it could be more clear. The finding could certainly be more clear, but looking at page 79 of your brief, where it discusses factor 24, the last sentence is, given his refusal to participate in sex offender treatment offered to him when she's gone through what the hearing examiner has gone through what the two bases are, and then I'll stop beating this particular horse so you can move on, but could we not interpret that as the hearing examiner's determination that she credited the finding that it was not for the reasons that that later your client gave, meaning confidentiality?
I disagree. She specifically stated in her findings, parole notations indicated that he refused to discuss the offense and was concerned about his comments being used in civil commitment proceedings. And that right there shows that she's acknowledging that he's refusing to participate because of confidentiality concerns. And she completely ignores the holding in Doe 23656. And she goes on to then hold that factor 24 as a risk increasing factor and holding it against him. And that is in absolute denial of the decision in Doe 23656. And unfortunately, the Superior Court went on to uphold that, again, not even referencing Doe 23656. So that is the case law is standing right now, and it needs to be held in this case. What I'm asking this court to do is to look at this case as a whole and excising factor 24 from the hearing examiner's decision, finding that there is not enough substantial evidence to hold that he is a high risk, the highest risk sex offender. In that note, I would like to jump over to factor. I'm sorry.
Counsel, I'm sorry. Before you do that, the board argues that even if we just disregarded factor 24, there was overwhelming evidence here to classify him as a level 3 sex offender. Do you want to weigh in on that?
Sure. The culmination of the errors in this case is the reason why this case needs to go back to the board. It's not only factor 24, which I submit holds a great, it held apparently a full weight. There was no other weight given to it. It in terms of, it wasn't a moderate weight or a threshold weight. It was given full weight. And so in addition to that, the other errors that occurred, going back to, I believe my first argument is the factor 2 argument, which I know has gone through a lot in the last year. Factor 2, the board argues is still a viable factor. I submit factor 2 is no longer a viable factor. There are so many holes in factor 2. One of them is shown in this case. The idea that factor 2 has 2 elements, but the board is only looking at repetitive conduct to apply the entire factor is an error. Repetitive and compulsive, those are 2 separate things. Repetitive may be the commission of multiple offenses, but compulsion is something else. It is something more psychological. It is something that needs more evidence behind it. It cannot just be applied because somebody has committed more than one offense. Otherwise, it would be factor 2, repetitive behavior, period. But it's not, it's repetitive and compulsive. So in this case, there was absolutely no finding that my client has any compulsion to commit sex offenses. In a case as this, factor 2 should not have been applied. It should not have been applied with full weight. Factor 2 is a high risk factor. It's given so much weight in these decisions, and it has so many errors laden in it. And this is one of those examples. Justice Milkey in 22188 stated in his concurrence, compulsion needs to be defined. It needs to have kind of its own stage. And I'm, paraphrasing, but you can't just put the two factors together, the two elements together and say that factor 2 applies. So in this case, factor 2 also needs to be excised from this hearing examiner's decision. When you take out factor 2, you take out factor 24, and then you look at 8 factors that have no weight assigned to them. This decision is not ready or able to be reviewed by the Superior Court or by this court because it is arbitrary. There are 8 factors that apply, but we don't know if there's threshold weight, moderate weight, full weight given to these factors. And so these decisions are issued holding my client at the highest level as a high-risk sex offender with a decision that does not uphold substantial evidence, and the board cannot show by clear and convincing evidence that he is a high-risk offender. For that, I ask that you remand to the board. Thank you.
Thank you, Ms. Green. Let me see if there are any further questions. Seeing none from my colleagues, Mr. Shanai.
If it pleases the court, David Shanai for the board. The first time that Justice Milkey asked me about factor 2 was about 14 years ago in a hearing, and he stayed with that issue right through. And the repetitive and impulsive in this case really is because this individual committed a second sex offense after being convicted of a first sex offense. That's where the compulsive nature comes in. Justice Wilkins in his declaratory judgment and Justice Mead in his argument in 22188, both were talking about the very first parts of factor 2, not the second and third part. And even Hansen in his studies and his testimony in front of the board, he's the one who came with the concept that to be compulsive, there has to be intervening, someone has to intervene, an authority has to intervene, and then the individual has to continue committing sex offenses. So factor 2 is applicable in this case, even in light of the Wilkins decision. I'd also point out that in factor 24, it wasn't argued at Superior Court that this individual refused sex offender treatment because of confidentiality. It was argued that refusal of sex offender treatment while incarcerated does not equate to higher risk. And that's what the studies were submitted on that issue. So again, the board would say that that issue is waived. But basically looking at the brief, I think I've briefed all of these issues well. Unless there's specific questions, I'll rest on my brief.
Well, Mr. Shanai, you heard Ms. Green's response to our questions about whether or not the issue was adequately raised in the Superior Court. Can you respond more directly to her comments?
Again, the issue that was raised in the Superior Court, and that's why the whole idea of waiver is that the Superior Court has to have the ability to look at the issue. In this case, the issue that the Superior Court was asked to look at was whether or not the research that was submitted proves that the refusal of sex offender treatment increases risk. The Superior Court judge was not asked to look at whether or not this individual refused sex offender treatment because of the non-confidentiality aspect of it. And again, looking at the facts in this case, in 2017, he didn't raise confidentiality. And what's interesting about this, he was set to be released or at least paroled sometime in 2019. He got a 10 to 15 in 2009. And it makes sense because the way the system works is that he would not have had the civil commitment issue come up until he was closer to his release, which would have been around 2018 to start the process. So if there was going to be a civil commitment, it would have been closer to his release date. They wouldn't start the civil commitment in 2009 or even in 2017. So his refusal in those years was not based on non-confidentiality. And I think that you can make that presumption that it was closer in time where to his release is where the sexually dangerous or civil commitment issue was raised to him. So I think it's not unfair to say that the individual, at least for the first 8 years of his incarceration refused sex offender treatment. And it didn't base it on non-confidentiality. So that could be considered by the hearing examiner.
So could you just give us a reference record to the argument that he made about factor 24 in the Superior Court, where you're saying that wasn't sufficient to preserve this?
I don't have the site in the record. I'd have to look through the record, but I'm reading the memorandum of the judge's decision and the memorandum submitted by the plaintiff. That's where the issue was raised as to, again, it's not the non-confidentiality issue. It's that refusal of sex offender treatment does not increase risk. That's what they were arguing. I think you look to the plaintiff's memorandum and you look at the judge's memorandum and decision, because again, the judge was not given the opportunity to consider the issue of non-confidentiality. And that's the whole concept of waiver.
Can I ask a question on a different topic? Attorney Chennai, Joe argues that there are places where the hearing examiner makes specific weighted findings and places where the hearing examiner makes general findings that I considered this factor. And I see Sorb's argument that certain of the factors identify with specificity when they can be weighed either less or more, and some don't. What's your suggestion as to where on the spectrum we put the I considered these factors for the factors that don't specifically identify when they can be weighted in a particular way?
Well, there's certain factors, again, I think when you get to there's two types of factors. There's static factors and dynamic factors. The static factors really focus around the sex offending behavior. Those ones are always, if they're applicable at high levels, either dangerousness or risk or both. It's issues such as criminal history. That's a dynamic factor because it's changing as individual could continue to change even past his sex offending behaviors. And in this case, I think the hearing examiner gave that moderate weight, the criminal record. And so those are the dynamic factors tend to be the criminal record, non-sexual violence, probationary issues, behavior while incarcerated. Those are dynamic factors. And the risk mitigating factors are all dynamic factors because they are the factors that develop over time, such as advanced age, support network, stability in the community. And those are weighted. I mean, the hearing examiner in this case did weight those. She looked at 33 and she gave him credit for 33, but limited it somewhat. She also did not give mitigating weight to future stability in the community. So the hearing examiner did follow the proper protocols by putting the dynamic factors and listing the weight she gave to those, both in her application of that factor and in her discussion. But again, the static factors, which focus around the sex offending behavior, those are always going to be put on as high or now the statutory factors like factor 2, they have a different weighting system. And factor 3 has a different weighting system because factor 3, if it's a prepubescent child, the risk of reoffense and danger is even heightened because of the age of the child. And it also indicative of possibly a sexual deviancy. But for the most part, the factors that are cited in my sister counsel's brief are static factors that were applied. And once they're applied at high levels. And if there's no other questions, I, again, would rest on my brief.
All right. Seeing none, thank you both very much for your argument. It's been helpful. The case is submitted and this Zoom hearing is adjourned.
Thank you.
So we'll see you in a couple